Good morning to all, and thank you very much for joining us today. As you know, the discussion about the intersection of climate change and investment law and arbitration has been ongoing for a while, but I think it's fair to say it's become a much more sophisticated discussion, and people are realizing it's significantly more nuanced than they might first have thought. There's clearly the obvious category of cases brought by fossil fuel investors against state measures intended to curb climate change, but it also covers cases brought by green energy investors against a state's failure to adopt or to maintain measures that address climate change. These cases often implicate the usual investment obligations, so you might expect to see fair and equitable treatment or expropriation, but they also implicate new obligations. And we're seeing, of course, environmental exceptions in new treaties, and language in treaties that allows for regulatory space, which might well be invoked in these situations. Perhaps more interestingly, we see not only international investment law being invoked, but also other forms of international law, for example, human rights. And the question becomes, how do these interact in an investor-state arbitration? So all of these are questions that are for us to deal with now as part of the practicing bar and as arbitrators. And we have this book today that is the platform for our discussion, Investment Arbitration and Climate Change, which is an absolutely tremendous volume that addresses a lot of these issues. We're very fortunate to have the book's two co-editors, as well as several of the authors of individual chapters. So allow me quickly to introduce our panelists for today. First of all, we have Annette Magnusson, who is a co-founder of Climate Change Counsel, which is a think tank that provides research, analysis, and advocacy related to the law of climate change and energy transition. And prior to founding Climate Change Counsel, Annette was the Secretary General of the Stockholm Chamber of Arbitration. Annette, along with her colleague Anja, will help to set the scene here on the types of climate-related disputes that we see, treaty interpretation, and systemic integration questions that arise. So Anja, of course, is our other co-editor of this volume, and as well, Anja is a co-founder of Climate Change Counsel. She's got extensive experience in investment and commercial arbitration. She was a member or a legal counsel at the Stockholm Chamber and an associate in the New York office of Jones Day. Next, we'll hear from Caline Mouawad, who is at Chaffetz Lindsey and has over 20 years of experience in investment and commercial arbitration. And she will talk about the chapter that she worked on, co-authored with Greta Walters, talking about the role of climate science at each stage of an arbitration. And you can imagine that that's obviously very pervasive from the very beginning of the case, setting out your expert reports, all the way to the end where you might be considering things like costs and damages. Finally, Oliver Hales is joining us today, and he is an assistant professor of law at the London School of Economics and Political Science, where he lectures on a number of things, including public international law, international investment, and transnational environmental law. And Oliver did a chapter that's very interesting on valuation and compensation, where an investor establishes that the host state measure were in breach. And then the question becomes, how do you measure compensation and what's appropriate in the situation? We have also tried to leave a fair amount of time for your questions and answers during the program. So please, as we go along, if you think of a question you'd like the discussants to address, pop it into the chat. And as soon as we go through our formal presentations, we'll be happy to go into a question and answer discussion phase of the program. So again, thank you very much. And I will hand it over to Annette.
Thanks, Meg, and hi, everyone. Thank you also to ICSID for hosting us here today, for putting together this program, to giving us an opportunity to talk about investment arbitration and climate change. As Meg alluded to, my task here today is to set the scene. So I will give a brief background to the book and then a quick overview of climate-related investment disputes before I hand over to Anja. To go back to the idea for this book, we need to go back 2 years ago, the starting point, and that was after the launch of a report that we published from Climate Change Council titled The Energy Charter Treaty, Climate Change and the Energy Transition. And this was one of the very first projects that we launched at Climate Change Council. And in the course of this study, we reviewed all of the publicly available arbitral awards rendered under the Energy Charter Treaty. So this was really all of the awards available or rendered before August 2021 that were in the public domain. And one of the purposes of the study was to get an insight on the ECT's effect on the energy transition and energy transition policies. And based on this jurisprudence, see if there could be any conclusions we could offer on the ECT's role in the climate transition, including how tribunals may approach future fossil phase-out cases. As alluded to by Meg, these cases is something we're seeing, and many of them came about or were filed right around the time when we started Climate Change Council. So we were expecting we would see more of that. What could the previous practice of the ECT teach us in terms of what we could expect in the future? So what then did the presence of climate change look like in the awards that we reviewed? And I should say they were a total of 64 awards that we reviewed for the purpose of the study. Well, none of the reviewed awards discussed climate change in substance. And despite the connection between global warming and energy policies, the reasoning around climate change in the context of renewable energy policies were really absent from these awards that we were looking at. Now, in a minority of the awards, a global climate law was mentioned as part of the factual background, and these were a few cases where the Kyoto Protocol was mentioned. Most of the factual backgrounds in these cases that we reviewed were earlier than the Paris Agreement, so it was really no surprise that we did not see any reference to the Paris Agreements in any of the awards. But in essence, there was really not much said about climate change or climate change policy. So the space, you might say, in this jurisprudence where we expected to find the climate change perspectives was really empty. There was nothing there. And this, I think, was one of the biggest surprises for us in the course of this research. When we launched the study, we received a lot of attention for the content, and it was quite well received. I think we can agree on, both Anja and me, both by the international arbitration community and from civil society. And we had really made an effort as we designed the research for the purpose of the study to involve both the private and public sector to really get a neutral stance on the research. And equally, after the publication of the report, we talked extensively about the report and the findings with states, with arbitration practitioners, with NGOs, and really had quite a lot of really good discussions on this interaction between international investment law and climate change. And hopefully the report was the starting point to inspire to bring some climate change perspectives into future cases. And as Meg mentioned, this focus on climate change perspectives in international investment law has really, since before and after, really seen an increase in the interest that it has received. And this interest has just continued after the launch of this report. And it is fascinating to see in the 3 years that we have had Climate Change Council, we have seen how we get more and more engaged in this discussion. So when Eleanor Taylor from Clover Arbitration approached us with the idea for this book, Investment Arbitration and Climate Change, it was really quite easy for us to accept this idea and embark on this venture. The objective then of investment arbitration and climate change is to analyze and explore the role of investment treaties in the climate transition, quite broad. And you could say this is a threefold objective. We wanted to explain the context that gives rise to investor claims related to state climate action. Also provide concrete ideas for how to argue and defend and assess these disputes, and also to explore the interaction between investment law, climate law, and human rights law. How do we align international investment law and investment arbitration more closely with global climate change objectives? This is sort of one of the overarching questions. And it does require a balancing act of states' international obligations to reduce greenhouse gas emissions to mitigate climate change, and the obligation or the need for states to provide foreign investors with a stable and predictable legal framework so that the investments needed to address climate change, that they actually will materialize, that they will happen. And this dual obligation, or this balancing act, is also reflected in the outcome from COP28 in Dubai, in the decision known as the UAE consensus from December last year, and which in the UAE consensus, which in climate law language, that would represent the result of the first global stocktake under Article 14 of the Paris Agreement. In the decision from Dubai, in the UAE consensus, the parties of the Paris Agreement recognized the need to transition away from fossil fuels and energy system. And most of you will recall how tremendous this was, that this language was in the end included in the final decision from COP. And this is also mentioned in the final decision, that they recognize the role of the private sector. This is sort of the other side of the balancing act. And the UAE consensus highlights the need to strengthen policy guidance, incentives, regulations, and the enabling conditions to reach the scale of the investments needed. So again, you see here this the balancing act and the dual obligations of the states. And we hope that this book will assist the lawyers and the policymakers that want to master this balancing exercise that will be so essential going forward. So what do we mean when we talk about climate-related investor-state disputes? There are not many awards in the public domain that directly target climate change action. But there are two main types of cases closely associated with the climate transition, and we have heard them being described in Meg's introduction. The first category of cases are the phase-out cases, the phase-out of energy associated with the climate crisis. These are the fossil phase-out cases, to curbing the use of fossil energy to mitigate climate change. There have been a number of cases filed, we know, but we have not seen as of yet any case that has reached the award phase, as they have been discontinued for different reasons, these cases so far. The second category of cases are the incentives cases, so the cases based on incentive decisions designed to attract investors in clean energy. And I think all of these cases illustrate the complexities that are involved when it comes to policy design for governments looking to live up to international obligations under international climate agreements. There are many cases here, more than 50 globally, and most of them are against Spain or Italy or the Czech Republic. And most of them relate to investments in renewable energy. So these are the two categories of cases. But a relevant perspective when we talk about climate-related investor-state disputes is wider than these two categories of the incentives for investments or the fossil phase-out cases. And the opening chapter of the book sets the scene here with an overview of cases which could have a relevance in a climate change mitigation or adaptation case scenario, even when climate change is not at the heart of the dispute used as examples. And state actions of potential relevance, which have been challenged in these climate-related investor-state disputes, are a wide category of cases, and they include, for example, decisions to restrict the exploration of certain resources, including oil and gas, or the revocation of exploration licenses, for example, for environmental reasons. Other cases concern measures taken for conservation of natural sites, and sites that in effect could act as carbon sinks. And other cases relate to permissions to conduct an operation that could potentially affect the environment. And these are cases including relating to the issuing or withdrawal of permits. This could also be a relevant category of cases in a climate change context. Other cases relate to change of state policy affecting certain business operations, including proceedings for awarding contracts. And this has been in the context of, for example, supply of renewable energy or change of regulatory environment for energy purchasing agreements. And other examples relate to decisions putting limits on greenhouse gas emissions and administrative decisions on pricing regimes for energy. Now, the reasoning of the tribunals in these cases may well be useful when arguing climate change-related cases. And we don't have time to go into the precise details of all of these examples here today, but I invite you to explore the first chapter of the book by Beata Gessel, Maja Fronczak, and Piotr Paprota, where they really set the scene with all of these examples for further thought going into the next chapters of the book. Now, it can also, of course, be discussed whether investor claims can result from states' failure to take sufficient action to limit climate change. This is a factual background more associated with climate litigation in domestic courts or international courts. And we have not yet seen this scenario in front of an arbitral tribunal. There is one case that is of particular interest, though, in this context, and that's the Allard versus Barbados case, because it gives an interesting insight into what it could look like if a tribunal were to import, so to speak, the obligations under international climate law into a proceeding. Because here, the tribunal had reason to talk about or reason around the setting of the standard of full protection and security, or defining the limits of the standard of full protection and security, in light of the fact that the state of Barbados is a party to a number of multilateral environmental law conventions, and the way in which this could potentially influence how you define the standard, this investment protection standard of the full protection and security. In this case, in the end, the state was successful on the merits, but this line of reasoning relating to this particular issue is quite interesting and could be relevant also for other cases. So I invite you to take a look at this, and it's quite extensively also described in the first chapter. And it will be really interesting to see a future case where the Climate Convention and the Paris Agreement, either one of them, where they are brought into the dispute, and where you see this balancing act of different international interests and obligations, which is this balancing act, which is likely to follow, where you bring in the UNFCCC of the Paris Agreement into a treaty-based investor-state arbitration case. So we have yet to see this scenario play out. And I think I will end here, and I will hand over to Anja, and she will continue to talk about treaty interpretation and setting the boundaries for the standards of investment protection in light of the climate crisis, and a few more things, I think, Anja. So Anja, over to you.
Thank you. Thank you so much. And thank you, Meg and ICSID, of course, for organizing this event. Yeah, so we've now heard Annette talk about different types of investment disputes related to the climate transition. And I think all of these disputes in one way or another highlight a potential or an actual conflict between international investment law on the one hand and other areas of international law on the other hand, like climate change law, energy transition, or human rights law on the other hand. So this conflict between different areas of international law is, of course, one of the drivers behind the effort over the past few years to revise and update investment treaties. But as we've seen, these reform processes, they take a long time. And there are over 3,000 investment treaties out there in the world. So this is all to say that I think it's likely that the first wave of climate-related disputes will arise under and to be decided under existing investment treaties, most of which are old generation treaties, treaties that may not have environmental exceptions or provisions protecting states' regulatory space. So if we make that assumption that at least this first wave of climate-related disputes will be decided under existing treaties, then it may be wise to consider how existing treaty provisions and existing treaty case law applies or should be applied in the climate context, in the context of climate-related investment disputes. And I think the best example here is really to look at is, of course, the fair and equitable treatment provision, because I think that's probably where many of these disputes will play out. And as I'm sure most people in the audience know quite well, the language of fair and equitable treatment provisions in most treaties is typically very vague, especially in these old generation treaties. So tribunals have, over the past couple of decades, come to interpret fair and equitable treatment to guarantee investors certain things like due process and transparency, proportionality, non-discrimination, and of course the dominant component of the FET standard, the way we now understand it, has undeniably become this protection of the investors' legitimate expectations. So over the years, the scope of these protected legitimate expectations has expanded quite significantly. Many tribunals have read FET to protect investors' expectations in a stable legal and business environment more broadly, right? So one tribunal put it like this. They said, there is certainly an obligation not to alter the legal and business environment in which the investment has been made. That's a very, very broad, that's a broad protection, right? What level of stability is guaranteed by fair and equitable treatment in the climate context, right? Because in the climate context, we're in a time of economic transformation and an overhaul of our energy system. And in that context, what level of legal and business stability can investors legitimately expect, right? What level of stability in this context is required by the treaty language? So, tribunals, I guess the question is, whether it's reasonable in the context of the climate crisis to interpret the FET standard as a de facto stabilization clause without more. So tribunals, so Annette talked about the fact that, and Meg also talked about how states have different legal obligations under different areas of international law. And of course, tribunals analyzing the fair and equitable treatment provisions of bilateral investment treaties, they typically do not consider that states have legal obligations under other treaties. It's not a factor that comes in very often into the analysis. But that is necessarily different in the climate context, because under climate law and under human rights law, states have positive obligations to reduce emissions, to reduce greenhouse gas emissions, and also to protect citizens against the effects of climate change. So I think that if tribunals don't adequately take those obligations under different areas of international law into consideration when they assess or decide these disputes challenging climate-related regulations or other climate-related measures, I think if tribunals don't take obligations under other areas of international law into account, they risk appearing out of touch with what's happening in the world. And this point was made quite eloquently by Professor Zachary Douglas in a dissenting opinion in a fairly recent case. And I'll read you what he wrote. He said, in an era where radical reforms in the energy sector are not only desirable, but necessary for the sustainability of human life on Earth, it seems incongruous now to be interpreting the FET standard as requiring states to buy back their right to implement those reforms at the highest price. Right? So he's highlighting the fact that in this time of crisis, we have to rethink how we interpret the FAT standard. And of course, the same could be perhaps said for indirect expropriation. I'm only choosing in the benefit of time to focus on fair and equitable treatment here. So I tend to agree with Zachary Douglas, as you may surmise. And I think it might be sort of wise to take a fresh look at the FET clause in this new context, in this, what I expect will be a sort of a wave of climate-related disputes. And for that purpose, here's the treaty interpretation part of my remarks. I think it's valuable to dust off a few really fundamental concepts of treaty interpretation. And the first and most central one, of course, is the principle of systemic integration. This doctrine embodies a preference, a normative preference in the international legal system for coherency, right? And it's codified in Article 31.3c to be precise, of the Vienna Convention on the Law of Treaties. And it's also included in the language of some investment treaties. But the Article 31 of the Vienna Convention, it requires tribunals to take into account any relevant rules of international law applicable in the relations between the parties, right? So arguably at this point now, this includes the Paris Agreement. It includes the Framework Convention of Climate Change. It includes international environmental law, and it includes international human rights law. Those are all relevant rules of international law applicable in the relations between the parties. So with this keeping systemic integration, this principle in mind, tribunals can't simply apply an investment treaty, the investment treaty applicable in the dispute, in complete isolation from other areas of international law. So that's systemic integration. And that kind of goes hand in hand with this other principle that I wanted to mention, and that's Jura novit arbiter. The arbitrator knows the law. And I mean, that a lot can be said about that principle, and not everybody agrees on it. But if you think about, if we look at this principle of systemic integration, which says that, you know, arbitrators, tribunals must take into account any relevant rules of international law. This necessarily means that tribunals aren't limited to the rules invoked by the parties to the arbitration. It's within the power of the arbitrators to draw their own legal inferences from the factual basis established by the parties. So, you know, that also means that the parties' failure to raise arguments based on other areas of international law, that doesn't excuse the tribunal in an investment dispute from applying that law if it is applicable. And then the third principle that I wanted to highlight is that the principle of stare decisis does not apply in investment arbitration, right? Arbitral tribunals are not bound by precedent. And of course, that means that prior interpretations of treaty provisions aren't set in stone. Even you know, these seemingly entrenched standards like the fair and equitable treatment standard, not entrenched, but like these definitions that we've all come to kind of take for granted, or that have become so well established, even those standards can be reinterpreted or resituated in this new context, in the context of these new climate-related disputes. And of course, I recognize that, you know, most tribunals want to contribute to the development of a coherent body of law, of course. But I also know that, frankly, that hasn't stopped arbitrators from breaking with earlier decisions when they find it necessary to do so. So with these principles in mind, systemic integration, Jura novit arbiter, and no stare decisis in investment arbitration, we should perhaps take a fresh look at how we apply fair and equitable treatment standards in climate-related disputes, right? This is not a question of disregarding investment treaties or denying investors the protection intended by the parties to the treaties, or the protections intended, you know, by the states when they sign the treaty. rather, it's like Annette said, it's about finding the balance between those protections on which the investors rely and the state's right and duty and obligations to regulate, to tackle climate change, right? It's about finding that balance. And I think in trying to find that balance, here are some questions that we may want to ask. And I will round off soon. I know that time is kind of tight, but so some questions just related to the fair and equitable treatment clause, right? So considering the states have obligations under other areas of international law to cut greenhouse gas emissions, how do we account for those obligations in the analysis of an FET claim challenging emissions regulations, right? Do we consider them as part of the definition when we define the content of the FET standard? Or is it up to the states to raise this as a defense, basically stating that any measure designed to reduce greenhouse gas emissions is, an expression of the state's police powers? So that's one question, right? Where do these other obligations factor into the analysis? Second question, in the context of energy transition, can investors have legitimate expectations of stability in the absence of a specific commitment or a stability clause, right? Maybe I'm trying to be a little bit provocative here, right? Considering that the energy sector is going through a complete overhaul and it's revolving very rapidly, under what circumstances is it reasonable for an investor to expect regulatory stability? And third and last question, to what extent do we think that the FET standard protects against regulatory changes that were reasonably foreseeable when the investor made the investment, right? For example, can an investor in a coal-fired power plant legitimately expect that the regulatory framework will remain unchanged? Or should that investor perhaps foresee that the host state will soon regulate to phase out coal because the host state has made certain commitments under the Paris Agreement? Or perhaps there is a case in national court compelling the host country to comply with its climate-related human rights obligations. So these are some of the questions that I find myself asking when I look at this category of disputes, of climate-related investment disputes. And of course, there are many other questions and a separate set of questions related to indirect expropriation. But to sum up, this analysis of FET claims in climate-related investment disputes is very much a novel issue. And there are very few, like Annette pointed out, there are very few awards that are directly on point. So it'll be very interesting, I think, to see how this plays out in this first wave of climate-related investment disputes that we're only starting to see now. And I only have, I'm over time, and I feel like I have a very short time to talk about these issues. So it was necessarily a superficial treatment, but for more in-depth treatment, of course, you should all read the book. And several chapters discuss and touch upon the issues that I've touched upon here, most notably the chapters focusing on human rights. One is by Helinor Dianzizu and Nikki Reich, and a second chapter on human rights is by Suzanne Spears. And then there's also a chapter relevant to this topic on renewable energy by Lisa Sachs and Ladan Maranoir. So I will stop there. Thank you so much. And I will hand over to Caline, who will talk about the role of climate science in investment arbitration. Caline, go ahead.
Thank you. Thank you, Anja. Thank you, Meg, for bringing us together today around this really important topic. And thank you again to Annette and Anja for allowing my law partner, Greta Walters, and I to contribute to this great book. So when we sat down to write our chapter for the book, we really asked ourselves the following question. Does climate science have a role to play in helping investment tribunals weigh, on the one hand, a state's alleged breach of its investment obligations, against, on the other hand, its right to protect the public interest in environmental matters? And this really goes to this question of the balancing act that Annette mentioned in her opening remarks, and these dual state obligations and competing obligations and how tribunals are called to address them. And the short answer is yes. I mean, climate science has a role to play. And in fact, it has a role to play at every stage of an investment arbitration, at the threshold phase, at the liability phase, and at the damages phase. So I will say a few words about each phase. And as Anja just did, I will refer you to our chapter for more details in the interest of time. But before turning to that, I do think I just want to remind you about that disclaimer that we heard about sort of investment arbitrations and investment awards related specifically and directly to climate change obligations being few and far between. So our findings and our remarks are really based on what we've seen in investment arbitrations that have an environmental component or a health component, which are quite informative by analogy. So with that disclaimer, I'll start with the threshold phase, which is the first phase. And by threshold, I mean jurisdictional or admissibility phase. And of the three phases, this is the one that is likely to have the least space for climate science because the issues in dispute are often legal in nature rather than technical or scientific. So we're fighting over the definition of investor, the timing of the investment, state consent, statutes of limitations, etc. But having said that, climate science could come into play when looking at whether an investment was quote unquote made in accordance with the laws of the state. And we see this reference to this language in investment treaties in the context of the alleged illegality or of the investment. But I think you could imagine a state trying to show that an investment was made in breach of its carbon emissions regulations or Paris Agreement commitments, or somehow failed to protect the environment in breach of local laws, and raising that as a jurisdictional or admissibility issue rather than a merits issue. So that argument has not yet come up. So it remains to be seen whether it might, and if so, whether it will be successful. So stay tuned. Moving on to the second phase, the liability phase, I think there are three different ways that we identified where climate science may come into play. First, climate science can assist a tribunal in comparing environmental conditions before and after the offending action, and then trying to attribute responsibility for any change. So climate science can help answer whether the state negatively affected environmental conditions, and by so doing negatively impacted the investment. But it can also help answer whether the investor's conduct damaged the environment so that the state is not liable under the treaty. And incidentally, this could also be the basis of a counterclaim if that's allowed under the treaty or the arbitral procedure. Second, climate science can assist a tribunal in assessing whether a state properly exercise its right to regulate for climate change reasons. And Anja touched on that briefly in her remarks. I mean, these policy shifts to implement climate change goals really sit at this intersection of the state's police powers and its international investment obligations. So, for example, a state like the Netherlands may pass a law phasing out power plants sourced by a particular fuel, like coal, but the investor may view this as an expropriation of its investment in that power plant. And I'll come back to that in a moment. Or states, like we've already heard, like Spain or Italy, may create incentives to attract renewable energy sources, like solar power plants. But when these incentives are revoked, an investor may argue that it's a breach of its legitimate expectations. And here, climate science may be used to defend a state's measure as well-founded, i.e. it's not arbitrary, it's not idiosyncratic. And scientific analysis and studies can help explain the rationale of the regulation. They may support its soundness and also establish a benchmark against which to measure the impact and effectiveness of the regulation. So as I noted earlier, climate science can help fill a temporal gap by tracking environmental conditions over time. And finally, climate science has a role to play at the liability phase to advance public interest positions of a third-party amicus. And so here, let's take the example of the Dutch Coal Ban Act, which phased out coal-powered fuel by 2030 so as to reduce greenhouse gas emissions. And this law was adopted due to the Paris Agreement on climate change and also the Dutch court decisions in the Urgenda litigation, and I'm using the American pronunciation. I don't know how it's pronounced in Dutch, but that decision and that litigation ultimately that resulted in a decision that ordered the Dutch government to adopt a more aggressive emission reduction pace. And so coal-burning power plant owners, like RWE and Uniper, commenced ICSID arbitrations against the Netherlands and argued that the Dutch Coal Ban Act deprived them, without compensation, of their investment until the end of their lifespan. And in RWE specifically, there were several NGOs that requested the tribunal to indicate an opportune time for them to request leave to make an amicus submission. And one of those amicus was the Urgenda Foundation, which had successfully sued the Netherlands to obtain this more aggressive emission reduction pace and ultimately obtain actually the very act that RWE was challenging. And that foundation had submitted multiple scientific reports in the Dutch court proceedings. So all of that arbitration is discontinued as of last November. It was really poised to give climate science a prominent role to help assess, for example, the extent to which a ban on coal-fired power plants effectively mitigates the impact of climate change, sort of the soundness of the policy, to assess whether such a policy may have the perverse outcome of stimulating emissions because of imports from countries with coal-powered electricity generation. And also, climate science could have helped assess whether there were less drastic measures that existed to reduce carbon emissions across the energy sector. So not just on coal-powered energy generators, sort of spreading the impact of the legislation across other sectors. So unfortunately, that case has been discontinued, but I suspect that there might be other cases that will give climate science a chance to show that it can help decide those kinds of issues. In the last stage, the damages phase, I know that Ollie is going to speak to that, so I'll just limit myself to two quick comments about the role of climate science at that stage. First, climate science can help establish the causal link between certain conduct and the losses suffered by the investor, and as well help to value these losses by looking at conditions on the starting date of the investment before the breaching conduct. So again, sort of filling in that temporal gap and looking at the evolution of environmental conditions over time. But then the flip point of that is that climate science can assist a tribunal in reducing or offsetting an investor's damages, or in awarding compensation to a state by way of counterclaim if one is permitted, due to an investor's contributory fault or environmentally harmful activities. And climate science can help identify and quantify the investor's contribution to its own harm, or more generally to environmental harm. At least it's poised to do so. So all this to say that the future looks bright for climate science and climate change-related investment arbitration, and there are multiple ways in which we anticipate that it can assist tribunals in their decision-making. These types of investment disputes are beginning to emerge, and they're bound to raise very complicated scientific and technical questions at every stage of the arbitration. And climate science will have a role to play in resolving some of these scientific and technical questions. So I'll end my remarks here, and I'll pass over the mic to Ollie to make his remarks. Thank you.
Thanks so much, Caline. And it's a tremendous pleasure to be hosted by the Center for this seminar. So the basic question that drives my inquiry today is whether an investment tribunal applying rules of international law should award compensation that reflects future income from fossil fuels, regardless of a state's climate obligations. And although this question is primarily doctrinal, I think it speaks to a problematic relationship I've observed among energy companies, NGOs, and states. So in very crude terms, energy companies have not yet internalized the international legal constraints on their operations, so they tend to overvalue their fossil fuel assets. Critics then hold up that number as the possible extent of taxpayer liability for ambitious climate measures as part of their campaign for states to exit the investment treaty regime. And so the NGO community has translated the industry's own valuations into an inflated arbitration risk, making themselves a key link in that chilling effect with which they're so concerned. Another part of the problem is that many scholars and practitioners have long assumed that valuation is primarily an accounting exercise best left to the quantum experts. Now, I don't wish to downplay the importance of such evidence, far from it, but the main takeaway from my presentation is that compensation is no less a legal inquiry than, say, the jurisdiction or merits of an investment treaty claim. In my brief remarks, I'll zoom in on just 3 stages in the quantum phase that provide possible pressure points, if you like, that may help counsel to identify opportunities to present arguments that legally frame the expert evidence in order to increase or decrease the ultimate award. So first, proving a causal link between the specific breach and the alleged injury. Second, selecting an appropriate method of valuation. And finally, forecasting and discounting future income. Underpinning all 3 stages is the basic point that any award for a treaty breach must be situated in a state's obligations to adopt other mitigation measures which are bound to disrupt the future value of fossil fuels, but do not themselves warrant compensation. So first up, causation. Under the law of state responsibility, compensation is a form of reparation for injury caused by wrongful acts. The claimant must prove that the injury was, in all probability, caused by the breach, or that the injury would have been avoided with a sufficient degree of certainty. 2 cases, I think, help us to determine when a claimant must meet this high threshold, each involving an extractive project that never commenced operation. In Tethian and Pakistan, the claimant had to prove a causal link between the wrongful denial of a mining lease and the profitable operation of a copper mine. By contrast, in Rockhopper and Italy, the claimant had already secured a right to be granted an offshore hydrocarbon concession, such that the tribunal undertook no causation analysis at all. So I think a key inquiry in phase-out disputes may be whether the claimant's entitlement to conduct a fossil fuel project was fully vested by domestic law or remained conditional on further regulatory approval. Similar insights apply to investments that were already generating income as going concerns at the time of breach, but were also being squeezed by the regulatory environment at large. Consider the NAFTA case of Westmoreland and Canada, the one that was dismissed for want of jurisdiction. The claimant alleged that Alberta's decision to phase out coal power breached several standards by offering payments to ease the transition for locally owned power plants, but not for foreign-owned coal mines. The claimant alleged injury of $500 million, reflecting its lost income if the mines had to close in 2030 at the same time as the plants. Now, assuming there was a treaty breach, the claimant would still have to prove that this particular injury was caused by the state's failure to offer transition payments. And frankly, it's hard to see how. The claimant's operations were already subject to stringent but unchallenged emissions regulations, such that several of their mines were slated for closure as early as 2022. To conclude this first point, inflated claims could be headed off by careful characterization of the specific breach combined with the high threshold to prove a causal link with the alleged injury. Now we turn to methods of valuation, which must allow the tribunal to determine fair market value with reasonable confidence. In defining the relevant market, willing buyers and sellers are assumed to be familiar with environmental regulations and their reasonably expected evolution. Amid the energy transition, a host state's nationally determined contributions under the Paris Agreement provide, I think, a reasonable starting point for market participants to form expectations about future measures that impact upon investment value. Such factors should thus weigh in a tribunal's selection of an appropriate valuation method, whether based on the cost of purchasing an equivalent enterprise, a comparison with available sales data, or by converting the expected income of the investment into a present value. In this short presentation, I'll be focusing on that latter method, discounted cash flow or DCF valuation, which is the most widely applied in both the energy sector and investment arbitration. However, a tribunal may only adopt this method if the investment was expected to produce legitimate income with reasonable certainty under the laws of the host state in the but-for scenario. So it's vital to identify which other regulatory or fiscal measures may disrupt the flow of future income from fossil fuels without breaching international law. Indeed, such measures may well be required by the state's multilateral obligations. In South Pacific Properties and Egypt, DCF valuation was deemed inappropriate when the project would have become illegal under both domestic and international law. There's a sound case that DCF is also inappropriate to evaluate compensation for fossil fuel assets where future income may only be generated if the host state doesn't fully perform its obligations under the Paris Agreement. And in this connection, it's worth recalling how some arbitrators have recognized the prohibition against unjust enrichment as a general principle of law that may assist in awarding compensation that takes into account all relevant rules of international law. Next, assuming DCF valuation is appropriate in the circumstances, let's turn briefly to how such factors may also weigh in the discounting and the forecasting and discounting of income. Tribunals are bound to face a range of expert opinions on the reasonably expected prices of oil, gas, or coal as the key value drivers of fossil fuel assets. It's become difficult indeed to reconcile the benchmark oil prices and industry forecasts on one hand with rival projections from independent experts and, say, the International Energy Agency, ranging from roughly $13 to $90 a barrel. For certain, however, a tribunal must account for any expected measures of the host state that would increase the investment's operating costs, reduce levels of production, or even result in future business failure through carbon pricing or competition with renewables. In my own view, these risks are better incorporated into the projection of cash flows rather than being applied at the end as a separate discount rate, although both options were addressed in an expert report by Compass Lexicon for the Netherlands in the coal phase-out case brought by RWE mentioned earlier, which I think is probably the most sophisticated attempt so far to integrate a state's obligations under the Paris Agreement into DCF scenarios. However, as my concluding remark, we mustn't forget that a state has obligations in respect of climate change and the environment under other treaties and customary rules, which are bound to be clarified by the highly anticipated advisory opinion of the International Court of Justice. And if investment arbitration is to thrive alongside Climate Action Counsel and tribunals would do well to recall that this regime is first and foremost a creature of public international law, which informs all phases of arbitration, including quantum.
Thank you very much, Oliver. That's great. We have a few questions for the panelists, and we're going to start by grouping the ones that basically talk about the structure of investment agreements. The first one is, are there specific provisions that ought to be included in investment treaties to better address climate change related issues? And if so, what would they be? And I leave that open to any of our panelists. Maybe Annette and Anja, you might have looked at that during your study.
The short answer is yes, there are. So, but the first thing that comes to mind, I mean, clearly there could be a catalog of different ways of looking at this issue. And so I'll start and I'll have Anja follow. But the first thing that comes to my mind is that you, as a state negotiator, to be specific on what kind of investments you seek to protect and attract with this treaty. So, and again, going back to what we see is necessary for the climate transition, we see this great need for investments to happen, but there are certain types of investments. And I think it's important to differentiate between investments that are supporting the energy transition or the climate transition and not extend that full protection to all kinds of investments equally. I mean, we saw that discussion on the DCT, the protection of fossil fuel investments. So I think so have a very good awareness of the kinds of investments that should be protected under the treaty. I think that could be a good starting point. Anja, if you want to jump in.
Yeah, I agree. And I mean, already, you know, we're seeing, you know, environmental exceptions being incorporated in new generation treaties. We're seeing provisions that sort of guard the state's regulatory space. I personally am not a huge believer that these provisions will make a very big difference. But what Annette is talking about, I think maybe it's a more thorough change in bringing, you know, in simply using the definition of investment as a way to limit the types of investments that are protected by the treaty, and investors in sectors that are not protected by the bilateral investment treaty, for example, may then have to consider other forms of protection, be that, you know, political risk insurance or something similar. Yeah, I think I'll. But Meg, can I go on to the second question about yeah, so there's a question here that says, if we've seen cases during our research where investors were deemed in breach of their concession contract or environmental laws by causing environmental damage to the states. And I want to point out here that most of the old generation treaties, of course, there are no obligations placed on the investors in those treaties. And there's also no way for the state to bring a claim. So in an investment, in an award, in a case like that, we wouldn't see, you know, decisions where an investor would be deemed in breach because there's nothing to be deemed in breach of. That said, of course, now this is changing. There's increasing discussion, perhaps it's also being seen more in the case law, I don't know yet, but of counterclaims, right? So a lot of the new treaties, and I know the ICSID rules also, they allow for the state to bring counterclaims. But then, of course, there has to be something in the treaty that places an obligation on the investor to act in a certain way. And so that could be, for example, a clause saying that the investor has to abide by domestic law, or specifically that it has to abide by environmental, climate, or human rights or labor laws, for example. And so if you have that, if you provide for counterclaims and you place certain obligations on investors in the treaty, then of course the state would be able to bring a counterclaim, and there would be a bit of more of a balance in this regard.
Another question you might actually want to address, Anja, is a question concerning the different generations of treaties, and in particular, their FET provisions. And do these, or would these have a different impact on the outcome in a climate change case? So
that's, I mean, I would hope so, right? Because states spend so much time negotiating and trying to come up with language that specify exactly what it is that they intend to provide in terms of protection for the investors. So I would certainly hope that the arbitrators then, when they're presented, or when they have a dispute under a provision that doesn't look like the old generation provisions, it's a more specific, more well thought through provision. I would hope that the arbitrators would try to give effect to the intentions of the parties. That said, last thing I'm going to say, I promise. There is a very interesting book by Professor Alschner. I think he's at the University of Ottawa. It's called New Treaties, Old Outcomes, or something like that. And so he has a very interesting study where he actually shows that the incorporation of environmental exceptions and other new additions to these modern generation treaties, they don't actually result in new outcomes, but rather arbitrators tend to read the new treaties and interpret the new treaties the way they interpret the old treaties. But I hope that that's going to change.
Let me put two questions together here. We've had one question about what would be the impact of a multilateral investment court on these kinds of climate change cases as they arise. And then a second one, which is in a way related, what is going to be the impact on concerns about the legitimacy of investor-state arbitration by virtue of the fact that you actually can arbitrate climate change issues, and presumably depending on the outcome of some of these climate change issues, will it affect commentary about legitimacy of ISDS? And that I know calls for a little bit of crystal ball, but if anyone has an opinion, we'd be delighted to hear what your thoughts are, how this links up with the big policy issues that are ongoing now.
I'll make a brief remark on that point. The Multilateral Investment Court, by my lights, has been proposed to respond to issues of legitimacy and inconsistency. But the real issue is correctness, whether decisions are reached by tribunals or by an investment court in accordance with applicable law. And whether another institutional forum does a better job of that or not depends on a whole range of factors. Certainly, there are some tribunals which are pretty top-notch in applying the law of treaties, state responsibility, and any relevant rules of environmental law to investment treaty disputes, and that's borne out by the results. Frankly, they're ones that tend not to attract the headlines as much, but that's just my reflex.
Oliver, maybe we'll continue with you for a moment. We've had a question about whether you think that the compensation, which includes lost future profits, basically a discounted cash flow, could be justified given the UN climate agenda and human rights obligations. And maybe a related question is one way to balance the rights of investors and the rights of states to actually just look at compensation, and perhaps instead of a DCF compensation, have some kind of sunk costs. So some kind of a median course that reflects the rights and obligations of each of the parties to the case.
Thank you, Meg. I'll take the second question first. You know, it was surprising with the modernization agenda of the Energy Charter Treaty. You know, they had fossil fuel carve-outs and so forth. No discussion on compensation. You know, perhaps the International Law Commission could pick it up. Perhaps it could be dealt with in treaty text more forthrightly. But at the moment, we're just dealing with the general international law on state responsibility. So then the question, going to the first point, is how do we reconcile the principle of full reparation with the climate obligations or other obligations of states under international law? And in my presentation, I was trying to think through how, as a matter of law and as a matter of fact, state measures adopted to pursue what the question asker calls the UN climate agenda, these ought to be integrated, and I do think greater attention should be focused at the back end of arbitration, an area which, as I mentioned, I think a lot of legal scholars have assumed wasn't fertile for systemic integration and those other types of arguments that were mentioned at the outset.
Could the integration be done as a matter of interpretation, or is it something that really needs to be expressed in new treaties? How do you do this systemic integration?
Well, systemic integration is a rule of treaty interpretation. Arguably, it's also a rule of interpreting and applying customary international law. I do think that much of the integration can be done as a matter of fact rather than as a matter of law, because you're looking to see what would be the evolution of the regulatory environment in the but-for scenario. And if there is evidence presented that is more consistent with the Paris Agreement 1.5 scenario, and perhaps tribunals are presented with that type of evidence. I gave the example of the RWE expert report. You would see, as a matter of orthodox quantum analysis, the de facto integration of a state's international climate obligations.
One of our participants has asked whether there are any new generation treaties that adopt the Paris Agreement and its objectives. Are any of you aware of new generation treaties that you would say are expressly or perhaps implicitly adopting Paris Agreement?
Certainly the modernized ECT had a reference to it. But then the old ECT had a reference to the UNFCCC. So
the most recent model BIT from the Netherlands has a reference which is quite clear to the Paris Agreement, although it's not a sort of, I don't think one would describe it as adopting the Paris Agreement, but the reference is quite clear there. And there's some interesting language in the African Protocol for Investments, the new African Free Trade Agreement, and the Protocol for Investments. There's some really interesting language there relating to climate change in the international instruments.
Right, thank you. There's an interesting question here, which is, how do investments impact the new trend that establishes ecocide as an international crime and the measures that states must adopt as a result of this stance?
Sorry, I need to,
Sorry, I
need to think about that.
Yeah, I need to read the question again. Yeah.
Well, the question is, how do investments impact the new trend that establishes ecocide as an international crime, and what measures states must adopt as a result of this? So perhaps is climate change issues being criminalized, or perhaps is that a way to attract more attention to the area?
I mean, sorry.
Okay.
I can't see that there would be much of a correlation between the two areas of international law. I mean, it's very, even though ecocide, of course, has received a lot of attention over the past year or so, I think it's really important to remember that this is an international crime that will be, at the level of crimes against humanity and genocide. So what we're talking about is, very, very extreme cases of extreme negligence or intentional destruction of natural resources or something of the sort. And frankly, I just don't think that that's going to have much of an impact. And I don't think that states' actions to implement ecocide is going to have much of an impact on the investment protection, in the investment protection context. Maybe Oliver, you have a different view.
I've heard some people describe the environmental damage caused by Chevron in Ecuador as a form of ecocide. And of course, there was a big dispute involving denial of justice for ghostwriting the judgment. And I was going to say that if ecocide, like genocide, were to be implemented in domestic legislation of various states, then it would be like any other criminal law, and the misapplication of that criminal law could breach an investment treaty standard. The only exception might be, and I'm thinking here of the Phoenix Action and Czech Republic case where there was a comment around not protecting investments that breach peremptory norms of international law. But we're far away off from ecocide even being a thing, let alone being recognized as use cogents. So like the time frame in which investment arbitration and climate change need to meet each other is a different one to that development of international criminal law, I think.
Caline, there's a question for you, which is about differing views among experts. And you've seen that in particular, I guess, among forensic experts. But is there a danger that there's not sufficient cohesion among climate science experts, that that's going to become a debated issue? And how will tribunals decide between one climate scientist and the other as you go forward in these cases?
I don't think that it's materially different than what tribunals are called to do already in terms of expert evidence and competing expert evidence, whether it's on science or law or damages or anything else. So I think that it's part of the healthy debate, quote unquote, and what tribunals will be called to assess. I mean, and let's not forget, tribunals also have the prerogative of appointing their own experts to counsel them, even when they have competing experts from both sides. So I don't know that it's going to be materially different from what tribunals have done to date.
Good.
If I can jump in,
sorry, go ahead.
Yeah, no, on the science side and sort of using the science in the hearing or in the proceedings, I think this is an interesting space also where I think much can be learned by looking at the parallel universe of climate litigation, because there you have a context where the climate science has been brought into the courtroom for a number of years now, and the sort of the established or beginning to emerge and established practice of which part of climate science is sort of, this is the part of the science that everyone agrees, and what's the frontier of the climate science. So that could be more sort of a risky, or whichever term you want to put on it to refer to, but whereas other parts of climate science is really, that's the established fact these days. So since it is an evolving field, that could be a relevant exercise to do, to see on the climate litigation side how science has been used and how the use of science has evolved over the years.
Exactly. Great. We've had a few questions on the interaction or no interaction, or how you see the interaction between ESG principles and ESG in the context of climate change. Do you see them as different buckets, or do they overlap, or how do you see those discussions in the climate change scenario?
I can, I mean, this is a question that we come up against quite often, because of course, ESG principles are very important, and climate is only one aspect of, you know, ESG or sustainability more broadly. I think if we try to bring all ESG principles into investment arbitration, we may sort of get lost. I think that climate change, this is the transition that's really, really urgent right now. Right now is it's net zero by mid-century. It's kind of it's now or never. So I'm not saying that labor rights or corporate social governance issues those are not important. It's just, you know, if you're going to have a revolution, you got to pick your battles, I think. So that would be my 2 cents on it.
And just building on that, I think, again, coming back to the fact that for the climate transition, the amounts that are needed for investments are just staggering amounts. So we just really need to mobilize a lot of capital. And of course, we know without stable legal environment, be that in a domestic or regional or even international level, for the capital, it will be difficult to mobilize that capital. So this goes hand in hand. And I think here, that's why the discussion on the role of international investment law is so important, to make sure that that it goes hand in hand with this objective. And again, going back to COP28 and the UAE consensus, the numbers are there, the ambitions are there. You need to triple the investments in renewable energy. All of these sort of ambitions So this is a good example, I think, of how two different parallel universes of the international law, the climate change law that is happening at the climate negotiations and the international investment law, could do a better job of talking to one another to make sure they work together.
We've also had some interesting questions on the role of NGOs and other entities that act as amici. Are they effective in bringing the tribunal's attention to climate change and to human rights considerations that arise in a climate change context?
I think the most effective instance of an amicus application is when the World Health Organization and the Pan American Health Organization made their submissions in the Philip Morris and Uruguay case. NGOs and local communities often get short shrift from tribunals when they make applications. So if there was a high-profile climate case and you could get an international organization with specialist knowledge in climate change, I won't single any out, but there are a few that come to mind, that could be tremendously powerful. And it's worth looking at which entities have been given leave to file written statements in the advisory opinion before the International Court of Justice.
Super. Another question that's come up is what substantive or procedural challenges might international investment law present for a mineral-rich country that is transitioning to a low-carbon future? So if you are the government of a country, what kinds of things do you need to be thinking about as you make that transition? Or are you able to make that transition?
This is the million-dollar
around
question.
transition minerals or lithium and so forth?
The question was a mineral-rich country that's transitioning to a low-carbon future. Does it prevent you from taking those kinds of measures? And what could you do substantively to ensure that? Or is there a procedural solution that would allow you to take those kinds of measures without presumably being held liable?
I guess you could harness international investment treaties to incentivize foreign direct investment in the extraction of minerals that are vital for the energy transition. If that's what the question's going to.
And another question that comes up is, do you see the involvement of climate-related issues in an investment dispute affecting the enforceability of an award in terms of Article 5 of the New York Convention? So is there any kind of a link between the outcomes of these kinds of cases and actual enforceability? And is there a public policy argument against enforcing what otherwise is a valid award?
There are many good questions here in this audience.
Very good questions.
We could have a seminar on each of these questions for a long time, but I know that the public policy exception is what comes to mind, and that's something that's been discussed from time to time. I don't have any examples of where this has actually happened, where an award has not been enforced because it was deemed in violation of public policy relating to climate policy of some sorts in the state for enforcement. But I know it has been discussed here and there, sort of in theory. I don't know how it would work out in practice, but it is an interesting issue, I admit.
Exactly. Another question is, how do you reconcile the need for stability in the legal framework as a requirement to attract investment in renewable energy and the criticism of renewable energy ISDS arbitration?
This goes a little bit to what I talked about in my remarks, right? That of course, so I think over the years, the trend has been in favor of not absolute, but very strong protection of stability. There's also, frankly, there's no evidence that has resulted in that, but for, this protection, we wouldn't have investment in renewable energy. That is a separate issue. But I think it's about striking the balance, right? This is sort of what all the speakers have come back to at some point. Yes, we need stability in order to bring about these very important investments, but at the same time, investment treaties are not insurance policies, right? If you start a business, like inherent in the idea of an investment is the assumption of risk. And so I think this will have to, be, that's why I actually look forward to some of these disputes not settling, not being withdrawn, but actually going all the way, so that we can see how council will argue these issues and how tribunals will analyze them. Because right now there's a whole lot of assumption and maybe a lot of fear. But in the end, when you look at the treaty language, it's quite broad. There's a lot of balancing that can be done. If you have good counsel and open-minded arbitrators, we will find that balance between stability and state obligations.
Can I just say that I just so agree with Anja that we need to see this being actually heard in front of a tribunal. And Anja talked about the Juranovit arbiter, but and we talked about systemic integration, but I think we are waiting for the case where these perspectives are actually brought into the proceedings by counsel. Yeah. So there are a lot of smart counsel out there and smart tribunals. So just bring it into proceedings and have the tribunals reason around it and see where we end up. I think we're all waiting for that to happen.
Exactly. Another one that perhaps goes in that category, but there's been some questions about due diligence and perhaps the role of due diligence by an investor going into a state and how that's going to relate to their legitimate expectations. Is that going to be one of the criteria or the considerations of a tribunal?
I think due diligence definitely will play a part. I mean, I think from memory, I think in the Orescu versus Argentina case, there was a discussion about the timing of the investment and whether the investor had a legitimate expectation that the framework would return to how it used to be, or whether it was already in flux. And so I think certainly from memory from that case and from other cases we've seen in the illegality context and the due diligence of the investor, that's definitely an aspect that's quite important. And I can only imagine that it'll matter here as well. I mean, are you investing at a time, at the beginning of all the ECT cases, or are you investing at a time, 5 years or 10 years into it, having seen the legal framework fluctuate over the years and sort of anticipate and seeing that the Paris Agreement and climate change has become such a more important part of the conversation and of each of the country's goals. And so as an investor, can you legitimately expect that there won't be future changes? So I do think that that's going to be, that will continue. I think it'll just become another aspect of due diligence that matters to everyone.
Yeah, exactly. And then a question that's an interesting one. What about a proposal for developing a climate litigation tribunal? And how do we address the complexities of developing a unified global treaty to establish an international climate litigation tribunal so that there's accountability for climate destruction on an international scale while you balance diverse interests? So I think the idea being, is it feasible to bring all of this, however you define it, into some kind of an integrated climate tribunal? Is that a good idea? Is that a doable idea?
In the 90s, the International Court of Justice set up a special chamber for environmental disputes. Not a single case was ever filed because environmental issues tend to be litigated when there's money at stake. So they tend to go through the WTO or through investment arbitration, or there might be human rights claims and so forth. I wonder whether, you know, the fact is, and this goes back to one of the watchwords of this seminar, integration. Like, you need to integrate climate law in all these existing instruments and institutions. So I doubt whether a standalone tribunal would add much.
I think oh, sorry.
Go ahead.
Well, just to tee off of what Ollie said, like there's just further fragmentation. And, you know, a tribunal constituted under an investment treaty instrument or a climate change instrument, and what's the scope of its jurisdiction and how to assess breach of obligations and then balance obligations that are not from the treaty that it's, you know, constituted under. I mean, there are lots of complexities there that can continue to further the fragmentation as opposed to this integration. So just creating yet another body that's just dealing with one, you know, officially dealing with just one part of it, I don't know that that addresses the issue, but Annette, please.
No, I was just thinking that one element of setting up new institutions, not least on a global level, is the fact that we are sort of running out of time. We need to get to net zero by mid-century, and so whatever we do in terms of setting up structures will just take away attention and funds from working with what we have, which I think is a wiser decision at this point, to make sure that whatever structures, whatever public international law instruments we can use, that we use them wisely to reach that mid-century net zero. And that is coming closer very, very fast.
Exactly. We've had one participant ask a question, perhaps for you, Annette, but when will the draft conciliation annex that's been discussed, there's been an expert committee, I think under the auspices of ICA, and the question is, when will that be released, or will that be released? And maybe as a sort of corollary to that, do we think things like mediation and conciliation as existing tools might be part of the answer here?
Well, to take the second part of the question first, I think yes, mediation and conciliation is a very efficient element in the toolbox, including for climate-related disputes, be that on a state-to-state level or be that in other contexts, not least where you need to resolve things by consensus, or you need to resolve it quickly, or maybe both. That's where these instruments are so useful. When it comes to the conciliation annex, the draft annex under the Paris Agreement that we have been working under the auspices of ICA, that will be discussed different engagements during the spring. So we hope to have something coming out later this year. So the idea to be able to discuss it at COP29 in Baku.
Perfect. Good. Well, I think we've come basically to the end of our time, and we've had some amazing questions. So I want to thank all of the participants for their thoughtfulness and all of the different angles that have been brought up today. And I'd like to very much thank our participants, our panelists here, who have each made some incredible points and really brought parts of the book to life. And for those who want to read more, we have the book. The book is out and available, and it really is a fantastic volume. So highly recommended. And all that's left is for you to join me in thanking our panelists. Thank you.